that, everybody? All right. So the Federal District Court Judge Roger Titus was saying careful and appropriate use of criminal history information is an important and in many cases essential part of the employment process. Even the EEOC conducts criminal background investigations as a condition of employment for all employees and conducts credit background checks on approximately 90% of its positions. Employers can run independent criminal background checks by pulling the information themselves from a number of places: law enforcement and correction agency records, registries or watch lists, public records, state criminal record repositories, and the FBI's Interstate Identification Index. Or employers can obtain criminal history information from consumer reporting agencies like HR Profile, and these are subject to notice requirements and use limitations of the federal law called the Fair Credit Reporting Act, or the FCRA. Well, there we go. So the EEOC regulates employers' use of criminal background checks under the federal law called Title VII of the Civil Rights Act of 1964. I'm sure you're familiar with that law. It protects individuals from discrimination in employment based on their race, color, religion, national origin, or sex. Even though having a criminal record is not a protected class or status under Title VII, the EEOC has prosecuted employers where their use of criminal history information results in a disparate impact on individuals of a protected class. This happens primarily with African Americans and Hispanics. The anti-discrimination laws generally prohibit two types of discrimination. There's disparate impact and disparate treatment. Disparate treatment discrimination is where an employer clearly treats applicants differently based on their race or their color, religion, national origin. An example would be rejecting an African American applicant based on a criminal conviction, but hiring a similarly situated Caucasian applicant that has the same conviction. These violations of disparate treatment discrimination are pretty easy to avoid because they are often intentional. You can treat people of different races with similar criminal histories equally, and you can avoid a disparate treatment claim. Disparate impact, on the other hand, is where a facially neutral background check policy disproportionately screens out individuals of a protected class, and the disqualifying crimes are not related to the job in question. These types of violations are more difficult to avoid. Intent is not necessary. Various national studies relied upon by the EEOC claim that African Americans and Hispanics are arrested, convicted, and incarcerated at rates that are disproportionate to their representation in the general population. In other words, these studies claim to show that minorities are more likely than the white population to be arrested and convicted for crimes, even though the rate of criminal activity among each race is allegedly comparable. Therefore, the argument is that minorities are more likely to be negatively affected by a criminal background check policy. Because employers have no control over crime statistics or who submits an application for employment, it's important to understand the EEOC guidelines and enforcement of background checks. On April 25, 2012, the EEOC published its Enforcement Guidance number 915.002. It reaffirmed its position that an absolute bar to employment based on the mere fact that an individual has a conviction record is unlawful under Title VII. The EEOC claims that such a policy would cause a disparate impact based on the studies it relies on that claim to show that minorities are disproportionately convicted of crimes. Therefore, the EEOC claims that criminal record information obtained from background checks can only be used to deny employment if the conviction is actually related to the job. According to the EEOC, disparate impact liability arises where an employer's criminal record screening policy disproportionately screens out a Title VII protected group, and The employer does not demonstrate that the exclusion policy is job related to the position in question and consistent with business necessity. This second prong operates as an affirmative defense, and that's what we're going to focus on documenting for your protection. Whether a truly neutral background check policy actually has a disparate impact on a Title VII protected group is outside of your control. Therefore, from a planning perspective, employers need to focus on qualifying for the job-related affirmative defense in the event a disparate impact occurs. However, where the EEOC files an enforcement action notwithstanding your assertion of the job-related defense, you can effectively defend the suit by attacking the EEOC's proof of disparate impact. At least 2 federal district courts have dismissed EEOC enforcement actions after excluding expert testimony on the presence of disparate impact. And we'll talk about this again later. According to the EEOC, employers can establish that consideration of criminal convictions is job-related to the position in question and consistent with business necessity in one of 2 ways. First, you can develop a targeted screening process. That means analyze the conviction in relation to the position and pair that with an individualized assessment of the applicant. The other option is to validate the conviction-based exclusion based on the Uniform Guidelines on Employee Selection Procedure. This validation relies on social science and studies that assess whether convictions are linked to future behavior, traits, and conduct that will have an impact on the workplace. This first option, the targeted screening and the individual assessment, is the affirmative defense that I'd like to focus on. A targeted screening is one that analyzes the underlying criminal conviction before excluding the applicant. This is as opposed to a per se exclusion based on the mere presence of any conviction. The purpose of the targeted screening is to exclude only those convicts whose criminal past bears some relationship to their ability to perform the job in question, taking into account the job requirements and the needs of the particular business. The case of Green versus Missouri Pacific Railroad tells us that a targeted screen should consider 3 factors. First, the nature and gravity of the crime or offense. 2, the time elapsed since the crime has been committed or the completion of the sentence for the crime. And 3, the nature of the position sought or held. Following a targeted screen, the EEOC encourages employers to perform what they call an individualized assessment before excluding the applicant to confirm that the individual actually poses a risk based on the conviction. The EEOC does not require an individualized assessment in all cases. The targeted screen may be sufficient where it's narrowly tailored to identify criminal conduct with a demonstrably tight nexus to the position in question. For example, theft convictions and for bank teller applicants probably have a tight enough nexus that an individual assessment isn't necessary. But the EEOC guidance says that screening without an individualized assessment may violate Title VII. So if you're looking for a best practice, you're going to want to do both steps of this affirmative defense. The narrowly tailored screen followed by an individual assessment. Now I know that you know the difference between an arrest and a conviction, but exclusions based on arrest records must also pass the job-related and consistent with business necessity defense pursuant to the above standards. However, employers cannot rely exclusively on the record itself because an arrest alone is not reliable evidence that a person actually committed a crime. An arrest is not a conviction. An arrest record is not the same as a conviction record. Relying on an arrest record alone may result in disparate impact on minorities because, statistically speaking, the EEOC claims that minorities are arrested at a rate disproportionate to the general population. Therefore, the EEOC claims that before excluding an individual, an additional inquiry must be made to confirm that the arrest record accurately reflects the applicant's conduct and therefore justifies the exclusion. To do this, the EEOC asks employers to examine the surrounding circumstances, offer the applicant or the employee an opportunity to explain the circumstances, and if the applicant or employee denies engaging in the conduct, you get to make the necessary follow-up inquiries to evaluate credibility, relying on public record sources or whatever information is available. Performing background checks in compliance with other federal laws or regulations is a defense to a charge of discrimination, even where the application of such regulation results in a disparate impact. Where federal law prohibits individuals with certain criminal records from holding particular positions or engaging in certain occupations, you may categorically reject those applicants, but complying with state or local law may not be a defense. The EEOC maintains that Title VII preempts state and local laws if they, quote, purport to require or permit the doing of any act which would be an unlawful employment practice, end quote. Therefore, employers may still need to ensure that the policy of exclusion is job-related and consistent with business necessity. Certainly, the state or local law would be one piece of evidence indicating this connection. The federal law, the Fair Credit Reporting Act, tells us that what we must do and what we cannot do related to consumer reports provided by consumer reporting agencies. Consumer reports provided by a CRA can contain criminal records, education, employment verification, reference checks, and credit history. When obtaining criminal background information through a consumer report, the employer must fulfill the FCRA requirements in addition to complying with the EEOC requirements. Prior to obtaining a consumer report, employers must first obtain the applicant's written permission and provide the applicant written notice that it might use this information in the consumer report for decisions related to employment. These notices are essential. There are a lot of Fair Credit Reporting Act violation class actions going on right now, so don't overlook this important notice requirement. The notice must be in a clear and conspicuous standalone document, but can accompany the applicant's consent form. The employer also is required to certify to the Consumer Reporting Agency that it is complying with the FCRA. If the employer finds convictions or arrests that it thinks merit exclusion, the FCRA requires that the employer provide the applicant with a pre-exclusion notice and an opportunity to explain. The pre-adverse action notice must include a copy of the consumer report as well as a copy of a document called a summary of your rights under the FCRA, which typically comes with the report. If the employer ultimately chooses not to hire the applicant, it must also provide a post-adverse action notice, either orally or in writing, indicating that the rejection was based on the report, the contact information of the Consumer Reporting Agency, and that the Consumer Reporting Agency did not make the employment decision, and that the applicant has the right to dispute the accuracy or completeness of the report and obtain an additional free report from the CRA within 60 days. When the EEOC's guidance was first published in 2012, there were EEOC enforcement lawsuits pending against two companies, Freeman, Inc. and Kaplan Higher Learning Education Corporation. In the Freeman case, the company was conducting criminal background checks on applicants, which included credit checks if the applicant was seeking a position that involved access to client or company credit card information, handling money, checks, or similar valuable items, or if the position involved other financial authorities. Even though the policy seemed to implement an extensive targeted screening. The EEOC alleged that the policy as a whole produced a disparate impact on African Americans, and even though they didn't challenge any of the specific procedures used by the company. The filing of this case in the first place is indicative of the EEOC's hostile position against criminal background checks. Similarly, the EEOC had also filed a suit against Kaplan for its use of credit checks, which allegedly had a disparate impact on African Americans. After discovering that certain employees had misappropriated student payments, Kaplan began race-blind credit checks administered by a third party to look for signs of financial stress among its applicants for positions involving financial access or access to financial aid, student accounts, or cash. The court in that case highlighted that the EEOC itself performs the exact same credit checks for the exact same reason on its applicants for 84 of its 97 job positions. As the EEOC Personnel Handbook states, quote, overdue just debts increase temptation to commit illegal or unethical acts as a means of gaining funds to meet financial obligations, end of the quote. Both of these cases, Freeman and Kaplan, were dismissed by the district courts after the EEOC's expert witness, Kevin Murphy, was disqualified. Mr. Murphy had been retained to testify in both cases to establish, through statistical analysis, the disparate impact. The courts found numerous flaws in his methodology in both cases. As a result, the EEOC failed to meet its burden of production on the disparate impact issue. So the courts never actually ruled on whether the exclusions from the policies in question were job-related and consistent with business necessity. But it does give us an alternate route in the event of litigation, aside from the affirmative defense of business necessity. You also want to look at attacking the evidence of the expert. The Sixth Circuit Court of Appeals affirmed the dismissal of Kaplan in 2004, upholding the lower court's exclusion of the expert's testimony. The opinion was highly critical of the EEOC's enforcement efforts in the case and highlighted in the opening sentence that the EEOC sued the defendants for using the same type of background check that the EEOC itself uses. In reviewing the lower court's exclusion of Mr. Murphy's testimony, the court stated that the EEOC brought this case on the basis of a homemade methodology crafted by a witness with no particular expertise to craft it, administered by persons with no particular expertise to administer it, tested by no one, and accepted only by the witness himself. Notably, this unanimous opinion was joined by Judge Damon Keith, known to be one of the more liberal federal judges. The EEOC's appeal in the Freeman case was also unsuccessful. On February 20, 2015, the Fourth Circuit affirmed the lower court's ruling. This court was also highly critical of the EEOC's reliance on an expert report containing mind-boggling errors and unexplained discrepancies, including, for example, double counting of individual convictions. In a concurring opinion in that case, one judge took issue with the disappointing litigation conduct of the EEOC, saying that the EEOC should have ceased pursuing this case once it became apparent that its expert, and therefore the EEOC's case, lacked merit. He said, the EEOC must be constantly vigilant that it does not abuse the power conferred upon it by Congress, as its significant resources, authority, and discretion will affect all those outside parties they investigate or sue. The Commission's conduct in this case suggests that its exercise of vigilance has been lacking. It would serve the agency well in the future to reconsider how it might better discharge these responsibilities delegated to it or face the consequences for failing to do so. Despite these failures in Kaplan and Freeman, the EEOC has continued to aggressively pursue employers' use of criminal background checks under Title VII. It launched 2 new enforcement actions on June 11, 2013 against BMW and Dollar General. Both of these cases alleged a disparate impact on African Americans stemming from background check policies that it claims lack an individualized assessment of the applicants. In BMW, 645 employees underwent a new criminal record check, 55% of which were African American. Of the 88 terminated, 80% were African American. In the Dollar General case, 1 applicant was allegedly rejected based on a 6-year-old controlled substance conviction, despite the fact that the individual subsequently worked for another discount retailer for 4 years without any incident. Another employee was allegedly fired based on a felony conviction, despite there being a mistake in the conviction record. These complaints may be useful insight on the EEOC's enforcement guidance. The BMW case is pending before the District Court of South Carolina, and the Dollar General case is pending before the Northern District Court of Illinois. We don't have any decisions yet, but we expect to get very important insight from them as they proceed. Following the filing of these 2 lawsuits, the Attorneys General of Alabama, Colorado, Georgia, Kansas, Montana, Nebraska, South Carolina, Utah, and West Virginia all sent a joint letter to the EEOC in July of 2013 criticizing these lawsuits and the EEOC's interpretation of the law as misguided and a quintessential example of gross federal overreach. The Attorneys General particularly took issue with the EEOC's push for individualized assessments and its view that bright line rules will rarely satisfy the job-related and business necessity test. They view the EEOC as improperly applying Title VII and expressed concern over the practical consequences, such as the additional expense that the EEOC's position could have on both public and private businesses. The EEOC responded with a letter dated August 29, 2013, pointing out that application of disparate impact analysis to criminal background checks is squarely within the EEOC's mission and is firmly rooted in both judicial and administrative policy. The EEOC also pointed out that bright line tests are permissible in some cases and that individual assessments are not always required but are encouraged as a second step to the targeted screening. Thus, it seems clear from this letter that the EEOC is sticking to its policies and will continue pursuing companies that lack the individual assessment procedure, like BMW and Dollar General. Also worth noting is Texas's attempt to attack the EEOC's enforcement guidance. In November of 2013, Texas sought an injunction to prohibit enforcement of the guidance against the state. It asserted that state sovereignty should preclude the EEOC from prohibiting categorical bans on convicted felons, or in other words, from requiring an individualized assessment. Texas argued that many state agencies have legitimate interests in banning convicted felons, and that requiring individual assessments imposes unnecessary cost and risk on the state and taxpayers. The case was dismissed on August 20, 2014 after the court ruled that the state lacked standing because its claims were not yet ripe for review. The EEOC argued that the Administrative Procedures Act only allowed the courts to review final agency actions, which the EEOC had yet to take against Texas because the guidance was not a final agency action. The court found that Texas was not presently at risk of being penalized for refusing to adopt the no bright line rule against hiring felons. Texas lodged its notice of intent to appeal to the Fifth Circuit following this ruling. Immediately following the Sixth Circuit's scathing opinion in the Kaplan case, the EEOC General Counsel, David Lopez, confirmed on April 10, 2014, that the EEOC would continue to aggressively pursue its campaign against employers' use of criminal background checks. He commented that despite being disappointed with the ruling in the Kaplan case, the decision is an evidentiary ruling that does not go to the merits of the underlying discrimination allegations made by the EEOC. He went on to say that the EEOC remains concerned about the impact of using credit history to screen out worthy applicants for employment, and that the agency will not abandon its efforts to challenge such practices for their impact on protected groups in appropriate cases. Despite the EEOC's lack of success thus far in their enforcement action litigation, they're still highly motivated in pursuing this mission. As a result, I'd like to leave you with some pretty simple takeaways here that you can take back to your office and implement in order to establish your affirmative defense to the extent that you can, and hopefully you'll never have to use it, and sort of fly under the radar of the EEOC. First, you should know, do not impose any categorical bans on convicted felons. Develop a policy that excludes individuals based on convictions only that are related to the job. Follow up with an individualized assessment of the applicant. Don't make a decision based on an arrest without an investigation, such as into a public record search, to confirm if the conduct engaged in is related to the job. Train hiring managers to limit questions to only convictions that are job-related and consistent with business necessity. Document all the research that you do and justification for every hiring decision. Investing a little more time up front could save you substantial time and money by helping you to establish the business necessity affirmative defense and minimizing your exposure to potential disparate impact litigation. That is what I have prepared to talk to you about today. I'm sure you have some questions for me, so I'll go ahead and let Jane, you can send me those questions.
All right, that sounds great. So to start off, and we have quite a few questions that have come by, so let me... Okay. Oh. All right, the first question is, if an applicant checks a box on the hiring website that states all of the information regarding background check, does something still need to be in writing, or does that online signature of approval suffice?
I'm sorry, can you tell me that one more time? If they click the box for what? Authorizing it?
Yes. The website that states all of the information regarding the background check. So the disclosure or the release of liability. If the applicant checks a box on the hiring website that states all of the information regarding the background check, does something still need to be in writing, or does the online signature of approval suffice?
I think the notices still for the Fair Credit Reporting Act still need to be complied with. And now it's possible they may be on the website, but you're going to need a record of that. So it depends on whether the website provides you with that record and contains the notices. But generally speaking, an electronic signature should be okay.
Okay, perfect. Then the second question is, if the person does not respond to the pre-adverse notice, do employers have a responsibility to reach out, or would we then make a call based on what we know?
No, your obligation is to provide the notice, and as long as you fulfill that obligation, you're fine.
Okay, all right. Another question that was asked is there a consequence from having the applicants provide a date of birth on the employment forms?
If you're talking about, is that an age discrimination issue? Generally not.
Okay. And why would an employer think that they couldn't ask that?
Well, I think that, well, age discrimination in employment is prohibited by a variety of federal and state laws. And so what we want to do is we don't want anyone to get the impression that we're going to use that information for an improper reason. So often you can include on your application an equal opportunity statement or policy, but it's also important, I mean, we all understand that age, date of birth is often required to confirm or corroborate or even to elicit the information for a background check to confirm someone's identity. So in that case, it's sort of consistent with business necessity in order to obtain it.
Okay, all right. Regarding arrest information, if a record comes back with a disposition that says set aside or deferred, how is an employer supposed to evaluate that disposition?
Well, it's not a conviction yet, so you need, or it may not be, so you need to treat it as an arrest. And so in that case, you have to take, if you want to exclude this individual based on that information, you need to take some additional steps to do that individual assessment to determine whether the conduct engaged in is contrary to the requirements of the position. So you'll essentially evaluate it the same way you would at a conviction, except you cannot rely on the fact of the conviction. You have to rely on the conduct underlying that person's status.
Mm-hmm. So in order to get that conduct, how far does the employer need to search or evaluate? Should they go back and request the court records or the write-up of what happened during the case?
Well, that's an interesting question because it depends on, the reason for the exclusion. If the reason for the exclusion is going to be that criminal status, we'll call it, then yes, you probably do need to do some additional research to corroborate that underlying conduct. But if there's another basis for excluding them, then you may be able to avoid that additional effort altogether.
Okay, all right. How do you actively evaluate the situation if the applicant indicates there is no criminal history, but the background check shows multiple convictions?
Well, first of all, you want to follow the FCRA requirements to make sure that there is not an error. Absent an error, you have dishonesty on the application, and that is sufficient grounds to disqualify them for the position. So you'd be making the decision then based on their dishonesty and not their criminal record.
Okay, great. Let's see, another question. In the state of California, how far back in criminal history can potential employers go for information related to convictions?
Well, that's a very good question, and I cannot tell you in the state of California. I practice only here in Ohio, Kentucky. So I'm going to have to either get back to you on that one or just tell you I'm not exactly sure.
Okay, perfect. Well, I will make sure that we send that question and follow up with the asterisk.
Perfect.
If a record said the person has an outstanding warrant, how should the employer handle it?
Well, again, if you're looking to exclude the individual based on those circumstances, you're going to want to know what the warrant is for, what was the conduct at issue, and then you need to determine if that conduct is related to the job in question and would be sufficient grounds to disqualify them from consideration. The warrant alone is not a conviction and cannot be the basis for disqualification.
Should the employer notify the local police?
There's no obligation to do that.
Okay, all right. How do you suggest trying a violent conviction to someone's role, tying it together? When I've done the individual assessments, there's always a story to go with it to make you believe that it was an isolated incident. It seems to be a tough spot for employers. Either don't hire the person or risk the EEOC charge, or hire them and then have the risk of violence in the workplace.
Yeah, you'll definitely want to look at the circumstances surrounding the incidents that led to the conviction, and you'll want to compare that to the type of workplace that you have, the essential functions of that job, what you know about your work environment. And you'll want to see how sufficiently tight that nexus is. If that type of conviction is one that would have a negative impact on your workplace, either has in the past or could be triggered by circumstances that exist in your workplace, then certainly you would want to, you would be justified in your exclusion. If the nexus is more attenuated, then you'll have to think, make more of a judgment call, maybe a bigger jump to exclude them based on the conviction alone.
Okay. If an applicant lies about work history or education, does that require adverse action?
I think it is entirely up to the employer if they wish to hire someone who's been dishonest or not. But I think in most cases employers find that a red flag and do not hire.
Okay. All right. And if you simply find a better applicant, you have 10 people apply to the job and one comes back, you did background checks on all of them, one comes back with a, criminal record. They maybe weren't your top applicant, but do you still need to follow adverse action even if you hire that better person?
What I would do in that case is document the entire pool of applicants and the reason for the selection of the candidate you wish to hire. And I don't think individualized assessment of the one candidate with a criminal conviction is necessary, because the reason for disqualifying him or not selecting him or her is not because of the conviction, but rather because of a better qualified applicant. You just want to retain that information because, again, you're not intending to discriminate against this convicted felon, but 5 years down the road, your statistical data could suggest that there's the disparate impact. So you'll want to have the documents. You'll want to have the notes to show it wasn't a discrimination issue, but rather a set of circumstances where there was a objectively better candidate.
Okay, yeah, so just document.
It's true. Create lots of paper.
Okay, next question. If the applicant was arrested, charged, and then went through a rehab program or a first conviction program, the court case was dismissed 3 years later because they went through that program, it is still within the 7 years, what is the acceptable line? Is the employer responsible for going back and looking, or are they allowed to use that as reason not to hire?
If the conviction is expunged, they certainly could not use that conviction. However, the conduct occurred. So if the information relating to the conduct becomes known to the employer, they can certainly consider that. They'll want to treat it just like an arrest where there's not a conviction. They'll want to look into the circumstances, find out what conduct actually occurred, and figure out if there's a sufficiently tight nexus between the conduct that the individual committed, not the crime, but the conduct, and the circumstances in the workplace. And if there's a tight connection there and it's job-related and consistent with business necessity to exclude that individual, then you can do so. Certainly you're in a stronger position if you conduct an individualized assessment. So if you decide that based solely on that conduct you want to exclude this individual, you should probably go ahead and take some additional efforts to make sure there hasn't been sufficient time for this person to be rehabilitated. You certainly want to evaluate the fact that they have been through some sort of diversion program or successfully completed, court-required a recovery program to make sure that that's an exclusion that is business necessary.
Okay, all right. Well, those are all of the questions. We'll give it one more minute. Anyone get your last-minute questions in if you have any. And in that time, it looks like everyone else has been taken care of. A big hand goes out to Taft Law and Miss Sarah Clay Layshock. Thank you so much for sharing your experience and your expertise with us today. I know that we are all going to go back and take a closer look at our procedures and work to implement what we've learned. This has been great, really valuable information. After we finish this webinar, check your email because you will be getting the HRCI certificate. It will be emailed to you along with the PowerPoint slides from today for you to review and your notes. We have our next Webby Wednesday. Our next webinar is going to be on May 20th at 2 p.m. when we will have our very own compliance officer, John Robinson, taking this discussion and delving further into the FCRA process and policies. So if anyone during this presentation has any additional questions, please feel free to reach out to either Sarah or myself because we will be happy to help you. You'll be receiving the invitation to that Webby next week, so we look forward to seeing you then. Thank you so much and have a great day.